Welcome to the Judicial Committee of the Privy Council, where today we're embarking on the third day of a hearing of two appeals from the Channel Islands, one from Jersey and one from Guernsey, both concerned with issues in the law of trusts. We've been delayed starting this morning because of technical problems, but we will proceed now. We're hearing submissions by Ms. Jordan, and so I'll turn to her now and invite her to continue her submission.
My Lord, thank you. Could I first of all mention that we had divided time between myself and Mr. Torb QC. So what I will try and do is finalise my submissions in about half an hour, so that then I can pass over to Mr. Torb, because I'm very conscious he has quite a lot to deal with in terms of the priority question. So to give him the maximum amount of time possible on that, I will do my very best to pass over, and I will pass over to him at 12. That being said, Your Lordship, could I deal with the points then we need to deal with today from our point of view? I'm going to look at the Article 34.2 point and how that's dealt with the courts in terms of our points that is really a right of retention rather than anything greater than that. And then I'll come on to the DORA point, the new point that is raised. And then just a few very brief comments in terms of the recoverable costs judgment, which is the other judgment which is being appealed. Before moving on to those points, could I just summarise where we ended yesterday in relation to the routes through the Jersey law, which we suggest are permissible. The first route was the reliance on John Martin's judgment. So that was the analysis that the right of equitable lien are permissible as an inescapable right of the trustee's office, and that was therefore imported by way of importation from the English law of trusts. And that concept would be able, in my submission, to be part of the wording that was excluded under the current statutory regime, which is said to deal with security interest over movables. That's the 2012 law that we looked at. That is the first route, and that's on reliance on John Martin's judgment, which we went through yesterday. The second route, which again we ended with yesterday, is the way the Guernsey Court of Appeal dealt with the matter. And that was in reliance on the paragraphs that we saw from re-esteem. And those are the paragraphs of the Deputy Bailiff at the time, Michael Burt, which showed the creation of equitable proprietary rights in the context of trust law, both for beneficiaries and for third parties in relation to criminal offences. And you saw that those paragraphs were relied upon when this point was raised in front of the Guernsey Court of Appeal in Investec to say that the equitable lien was in existence in Jersey law, and that was also approved by the Learned Commissioner when he considered the point in Jersey, as you will have seen, and we went to his February 2015. Yes, Lady Arden.
Could I just ask a quick question? Could one not also say it's a necessary inference of Article 32 that there is a right of indemnity?
Yes, indeed, Lady Arden. And also, I mean, there are other routes in terms of consistency with Jersey law. And the third that we looked at yesterday was Lord Briggs' question. If you saw the different indemnity as a right to go to court, obviously, and it was proprietary in that nature, then there would also be no inconsistency with the Jersey customary law, which is the point that's being raised.
But my route is a more direct route. My suggested route, if it works, I don't.
Yes, That Lady Arden, the Article 32 route is a corollary, really, of what the Guernsey Court of Appeal was saying. They start with the passages from re-esteem. They say that shows there's nothing in customary law which stops the creation of an equitable proprietary right in trusts, and then they move on to the application of Article 32.
But surely under the law of the islands, statute law prevails over customary law. It displaces it.
Yes, yes, that's right, Lady Arden. If directly it abrogates from it, then
But surely by necessary implication is good enough.
Yes, if one can imply that, then yes, that's right. That is good enough. Quite. And if there are no further questions, thank you, Lady Arden. I'll move on then, and we can deal with this relatively quickly. If I can ask the panel to turn to page 1064, that's the case of Caversham Trustees Ltd. So it starts on 1064. I won't take the course all the way through that, but it does merit reading because it is a case which is very frequently cited in Jersey for the suggestion in relation to what a retiring trustee should expect by way of reasonable security. And in this case, it's Commissioner Clyde Smith's judgment. There was various argument between Caversham, who were the outgoing trustee, and the new trustee about the terms of the indemnity. And that argument involved not only an argument about directors and officers, which you will have seen from the indemnity in this case was included, but also the question of whether associates of the firm would be included as well. And the Royal Court was particularly critical of the fact that the negotiations took 8.5 months to conclude. And it says in terms that it would have expected it to take 3 months to conclude, and that is necessary in terms of the operation of the new trustee and indeed the trust. And moving through the judgment, the key point here is, as it is in many cases, that the liabilities that Caversham were concerned about at this point were their fees. So that being said, the key point is paragraph 31 of the judgment, and that's at 1073. And I'll read that out for Sir David. In the matter of Carafe Trust, which is the other case which is authority in relation to what reasonable security is, the court held that it was improper for a trustee to seek security over the entirety of a trust fund until its disputed fees were paid. In that case, the court found that the trustee should have retired when the beneficiary offered to pay into escrow the full amount of the disputed fees, which gave the trustee all the security to which it was entitled. Although its decision was handed down the 16th May 2005, it confirms what should have been clear to Caversham in this case and its advisors, that the right to security is a right to reasonable security, and that in seeking to retain control over the entirety of the trust funds, the Caversham trustees were exerting improper pressure. And if one reads this case, you will get the idea of the kind of A, negotiations that go on in relation to ADORA, and B, how the courts see the matter of reasonable security. So there isn't, for example, a question of contingent liabilities, because it is very much concentrated on what the liabilities are at the time, what the trustee knows the liabilities are, and that's why really it's concentrated on fees and expenses of the trustee. And it's for that reason, and Lady Arden.
That's just the practical approach. It's not necessarily the legal approach. that you ignore contingent liabilities?
Well, the difficulty is that, of course, in terms of the legal approach, unless you have that equitable proprietary interest, which I would say would form part of the reasonable security, because that is a fallback, unless you have that, you're only ever subrogated to the rights of the current trustee.
But that doesn't have to be quantified, does it?
I'm sorry, help.
I'm sorry, it doesn't have to be quantified.
No, that doesn't have to be quantified. But it's the point is that when the courts go through the process of applying Article 34(2) and indeed 43A, what they are looking at is the practical circumstances existing at the time. So it's not looking at any kind of protection for future liabilities. So what you don't have is a discussion by the trustee of, I am concerned about all these later cases that I might be sued.
I see. No question of having a guarantee or a bank guarantee or an insurance policy to cover the contingents.
No, so those kinds of questions are dealt with only by way of negotiations under the DORA. And what you don't see is the court dealing with those kinds of issues under reasonable security questions. It's very much limited to those practical issues of fees and expenses. So the way that the Jersey courts look at it is very much as we saw in Lewin yesterday, that really they want the assets moved to the current trustee, and they need that because it would otherwise cause significant issues between management of the assets. So
one would have thought that meant that the outgoing trustee was in a strong negotiating position.
Yes, I think that's right in terms of the negotiations of the DORA. That's right.
Okay.
But yes.
But not the court.
Yes, indeed, Lady Anne.
But the court must have the ability to decide whether the outgoing trustee has indeed been provided with reasonable security within the meaning of section 43A.
Yes, the court certainly does have that ability, Lord Reid. The point is that if you said there is no equitable proprietary right, because what the court does now, following ReZed and Investec, the court, and an example of this, I won't take you to it, you can look at it, and we don't have time today. But if you look at the Velos settlement, which is Jersey supplemental bundle at paragraph 36 of that case, and that is at page 201, the relevant paragraph. If you look at that, which is a much more modern case, the court specifically referred to the equitable lien as being one of the matters, as well as the DORA and particular security accounts, which it takes into account when considering whether a trustee has had reasonable security for the point of passing over the trust assets. So the court takes...
Are you interpreting section 43A as it now is, insofar as it deals with security for the former trustee's liabilities, as sitting alongside a right under the customary law, which you've described as an equitable lien?
Yes, exactly, Lord Reid. And the way the courts look at it, because largely those kind of practical issues, they take into account that you have that right sitting alongside it, and they take that into account. And you'll see that in the Velos settlement. They specifically refer to the equitable lien rights, Lord Briggs.
I'm slightly puzzled by this, by your suggestion that we're mainly dealing in a practical negotiation of a DORA with liabilities which are other than contingent. If a trustee has a current entitlement to fees or a current liability or debt, and the fund is solvent, then surely that will just be paid.
Yes, Lord Briggs.
It's only if the liability is future or contingent. Or, for example, the new trustee is disputing the old trustee's claim, that some sort of security is going to be needed, isn't it?
That is exactly right, Lord Briggs, and that's why in most cases, and probably right, why this case is actually so rare, because you're absolutely right. In most cases, it's paid, and therefore it's not really seen as to whether you come under your equitable lien rights or your DORA rights, and we rely on both. But because it's paid. In this case, the problem you have is that if you come to the door and the trustee says no, that is where the separate equitable lien rights become very important. But you're absolutely right. Yes, Lord Patton.
Sorry, just a small add-on to that. Can the court, under 43A, order the new trustee to execute an actual charge over the trust assets in favour of the outgoing trustee?
I think they can. I think they can, as a matter of law, Lord Patton.
So that if the outgoing trustee had sufficient foresight to see that there might be liabilities further down the line, I mean, I appreciate the difficulties about that. It could say, well, I want to charge over the trust assets to secure those future liabilities, which presumably would give it priority.
Yes, exactly. That would, Lord Patton. The problem you have with that is the question of reasonable. That notion of reasonable security, and that's really the issue with those kinds of debates, because they simply haven't come before the court. And if they did, that question of reasonable would be that would be the determining factor. Really, it would be how reasonable that suggestion is. And I go back to the point about that we saw yesterday in Lewin. There is significant difficulty if one looks at that possibility in terms of a previous trustee having any kind of formal legal charge over the assets. But you're absolutely right that in other circumstances, if the panel is against us in relation to our proprietary rights, then in order to provide for these kinds of liabilities, you would have to have those kinds of negotiations potentially, and you would potentially have to have those arguments before the court. Because
And am I right in thinking that this would take the form of an application under Section 51 of the Act for an order concerning the administration of the trust?
There's two ways it could occur, Lord Reid. The first way, the way these normally occur, is that either a beneficiary or the new trustee applies to say the old trustee is being unreasonable, or alternatively the old trustee applies to say this is the security I have to have before I retire or resign.
Yeah.
And yes, that's quite right. It is done by representation. Havisham was slightly different because rather than looking at the issue of what reasonable security was, it was a preliminary issue in relation to losses arising from the delay. So it occurred after the assets had actually been dealt with. That leads me on to the DORA point, and much of what we said crosses over with the DORA point. And I should say, first of all, this is an entirely new submission. It was never previously raised before either the Commissioner or the Court of Appeal, and indeed it wasn't raised in the grounds of appeal. And we have relied on both our equitable lien rights and our contractual rights under the indemnity. And that is because, as we've discussed, the DORA rights are actually additional to our equitable lien rights. Our written case at paragraph 8, subparagraph 2, which is on page 765, refers to our letter on the 12th of July 2013, which makes clear the different rights that we seek, both the equitable lien rights and the contractual rights. And as well as that, you have already seen the judgment of the Commissioner, which was at page 23 of the bundle, and specifically at paragraphs 10 and paragraphs 13. And he talks about it as a separate equitable lien right. And if we can very quickly go to Lewin, which appears at 4200. And it's paragraph 17076 of Lewin. And again, I'll just read out the first few sentences. It is to be noted that covenants for indemnity in favour of former trustees, as distinct from equitable rights for indemnity under the general law, have contractual effect only. As such, although they may enable the former trustee to reach the trust property by way of subrogation to the trustee's rights of indemnity under the general law, like other contractual rights against trustees, such covenants may be of limited or no practical assistance to the outgoing trustees unless accompanied by express security arrangements if the new trustees fail to comply with their obligations and the trust property has gone. So the argument that is now made against us in relation to the DORA, and I should say that this argument only applies if in actual fact you're with me on the point that we do have equitable proprietary rights. So it assumes that under Jersey law we have those rights, and I think it is accepted there is nothing express in that DORA which abrogates those rights on the behalf of ETJL. So what is said is by implication, simply by agreeing that DORA, we have then waived our equitable proprietary rights. That is a submission which has extremely serious consequences because of the way that DORAs are used in Jersey in particular. They are standard form, as the Jersey Appellants said, and they are used in order to allow the current trustee to give up the assets, as we've seen in the Caversham case. So the suggestion that every time a trustee enters into one of those arrangements, that they waive their equitable proprietary rights by implication simply goes too far to be acceptable. I don't think I can go so far as to say that might not ever be possible, with one reservation, which is that, of course, as we were discussing, as you have seen through the last few days, the indemnity rights are important not only for the trustee, but also creditors claiming through them. So this point would also have a great significance in relation to creditors claiming through you.
Could one put your point this way, that the DORA should be interpreted against the legal context, which is that both parties to it know that there is an equitable right, and therefore the DORA is to be understood and interpreted in that way. So yes, it would take something positive.
Exactly, Lady Arden. Yes, with respect, that's extremely helpful. That is exactly right. And in my submission, it would take very clear words to actually give up those equitable proprietary rights, because, as you rightly say, these are two trustees who are well aware of the extent of the rights that they are discussing, and well aware that what they are talking about in terms of a DORA is a contractual right. So you are subrogating to the current trustee's indemnity. I'm very conscious of time. So in terms of priority, I'm going to hand over to Mr. Torb QC in relation to that point. And we adopt his submissions on those points. Could I ask the court to consider, when they are looking at those normative and fairness or policy considerations, we list out several points to that in our written case, which is at paragraphs 88 to 94 of our written case. And I'd ask the panel to additionally consider those points in terms of the normative and fairness issues. And on the recoverable cost judgment, I don't think I need to say very much more than is in our written case. That is dealt with at page 805 of our written case at paragraphs 105 to 108. And again, can I ask the panel to consider those when they are considering the recoverable cost judgment, as well as what is said by Logan Martin's judgment in relation to that issue, which in my submission is entirely orthodox and an entirely appropriate approach in relation to those costs. My Lords, I have saved 2 minutes, which I think Simon Torb may need. And so with that, I will rest on my submissions. Thank you.
Well, Ms. Jordan, we're very appreciative of how you've managed to fit your submissions into the greatly truncated time available. And we will, of course, consider fully the submissions you've made in your written case.
I'm grateful, Your Lordship. Thank you.
Mr. Torb.
May it please Your Lordship, I'm grateful to Ms. Jordan for truncating her time. It was originally agreed between us that I would have 2 3/4 hours, that's to say start at 11:15. So I'm going to have to truncate my submissions very substantially. But Your Lordship has a full written case on many of the issues. The position of the former trustees, Investec and Bayer, is that the courts in Guernsey were correct to hold that the right of indemnity of the former trustees out of the trust assets had priority over the rights of indemnity of the later trustees. If I may, I will summarise the reasons before turning to them in detail. Our first submission is that as a matter of law, the former trustees' right of indemnity conferred on them a preferred beneficial interest in the TDT assets of a proprietary character, and it is commensurate with their right of indemnity. Linked to that, we say the Jersey Court of Appeal and the Guernsey Court of Appeal were correct to hold that the first in time rule applied. That rule governs competing equitable interests in the same property. The preferred beneficial interest of a trustee in trust assets is an equitable right of a proprietary character. That interest is therefore akin to other comparable equitable interests to which the first in time rule undoubtedly applies. And the board, we say, should apply the rule to the question here for the same policy reasons that the rule applies to other comparable equitable interests. And I'll come to the policy. There is a linked question. The Jersey Court of Appeal and the Guernsey Court of Appeal held that for the purpose of the first in time, the date of the trustees' appointment as trustees is the relevant date for considering when its right of indemnity and beneficial interest arises. And therefore the ranking of the rights of successive trustees depends on that date. And that flows from the proposition that the trustee's right of indemnity is a single right of indemnity in respect of all its liabilities which it's entitled to be exonerated for or reimbursed. And we respectfully submit that that decision was correct too. No other date for ranking was appropriate, and we'll explain why that's consistent with the decision of the High Court of Australia in the Amarind Carter Holt case. The panel will have seen that we have an alternative submission or alternative basis on which the former trustees say that the panel can reach the same result, giving priority to former trustees. And that is because when, on the 2nd of July 2010, the former trustees were removed as trustees by Mr. Cengiz, exercising his power of removal, former trustees retained legal title and possession of the trust assets to protect their right of indemnity out of the assets. And that was in respect of liabilities which, if not finally quantified and disputed, were known. And they retained them as a form of reasonable security in respect of those known, actual, or prospective liabilities. And we submit that their legal rights gave the former trustees' right of indemnity priority over the later trustees' rights. There are two subsidiary issues which are covered in our written case in section F and section G of our written case, which may well be academic, and I certainly won't have time to deal with on the current timetable. Your lordships will recall, ladies, my ladies will recall that in the statement of facts and issues, there was a second issue identified, which is whether a trustee's right to be reimbursed out of the trust property for its expenditure that's occurred as a trustee takes priority over the rights of its own trustee creditors to have recourse to the trust assets by subrogation. As we've explained in section F of our written case, that issue appears to be academic because as matters have developed since 2019, the former trustees, Investec and Bayer, have no separate trust creditors. Their only claim on the assets is in respect of reimbursement of the legal costs which they've had to pay out of their own pockets, and a relatively small amount of remuneration which was due to them when they were removed as trustees but hasn't been paid. But if it were necessary to decide that issue, and Lords, we don't encourage the panel to do so because it is active, then we submit that the Guernsey Court of Appeal got the issue right and found correctly that the trustee's own right of reimbursement takes priority over the trust creditor's rights. And I will just show you the panel at the end the relevant reasoning in the, if there's time, the Guernsey Court of Appeal. There has been talk of the question whether or not the trustee's own right of remuneration takes priority. That's not actually an issue which was appears in the statement of fact and issues, or on which there was an appeal. So I don't propose to deal with it. But I remind the panel that the Guernsey Court of Appeal did decide that the former trustees' past remuneration ranked ahead of the trustees' prejudice claims in the same way as the trustees' right of reimbursement ranked ahead of the prejudice claims. And finally, in section G of our written case, we have addressed an alternative argument which we ran before the Royal Court of Guernsey and was dealt with in that judgment there, and was also running the skeleton argument before the Court of Appeal in Guernsey, unnecessary to return it. And that issue is as follows. If the board decides that neither former trustees' retention of legal possession of the assets, nor the first in time rule confers priority on former trustees' right to indemnity, former trustees suggest that the board should not simply direct the pari passu scheme of distribution, but instead remit the matter to the Royal Court of Guernsey to decide what, in the circumstances, would be the most fair and just solution. And there is precedent for that sort of approach, because even in cases of mixed funds where there has been a prima facie pari passu distribution proposed, the court has allowed specific applications to be made by reference to the facts. And that one finds it's mentioned in section G of our argument. But I want to focus on the two principal issues here, which concern the ranking, the rights priority as between the rights of indemnity of successive trustees and the submission based on the retention of legal possession by the former trustees. Before I go to that, can I remind the panel very briefly of the key facts here, which have not hitherto received any consideration in the submissions on the Guernsey appeal. As the panel will know, Investec was originally sole trustee of the TDT from the 21st of August 2007 until the 2nd of July 2010. Investec and Bio were joint trustees. During their joint trusteeship, the former trustees incurred liabilities primarily to the BVI companies, who are the first to fourth defendants in the proceedings. And in 2010, the total sums claimed by the BVI companies, ignoring interest, were approximately £180 million. Glenalla, the first defendant, claimed €78 million. Thorson, the second defendant, claimed £80 million. And the fourth defendant, Oscatello, claimed some 39 million odd, under what eventually turned out to be a restitutionary claim. As we know from Investec 1, that was held to be a bad claim. But the other two claims, amounting to approximately 140 million before interest, were held to be good claims. In 2010, the liabilities of the trustees to the BVI companies substantially exceed the value of the trust assets by a factor of somewhere between 3 and 4. When we were before the panel in 2017, the figure that I had in mind then was the assets were thought to be worth somewhere between, the gross value of the assets was thought to be worth 40 to 50 million. The most recent estimate is that they're worth 55 to 60. But on any footing, the fund value of the assets in the fund was far too small to meet a fraction of the liability of BVI companies. the BVI companies claimed against the former trustees that former trustees were personally liable, and the trustees couldn't rely on Article 32(1)(a) of the Trust Law of Jersey. And ultimately, the BVI companies made a direct claim on the trust assets. At the same time, Mr. Cengiz, who's the principal beneficiary of the TDT, disputed that the former trustees were entitled to discharge any debts due to the BVI companies out of the TDT assets in exercise of their right of indemnity. And he said they had acted in breach of trust. So in March 2010, while Investec and Bayer were still trustees, they issued the present proceedings, which are known as Guernsey 1, against the BVI companies for declarations as to the parties' respective rights and liabilities. Now, after the proceedings had been issued, on the 2nd of July, Mr. Cengiz exercised his protector's power to remove Investec and Bayer as trustees, and he appointed the 5th defendant as a successor trustee. Successor trustee is now known as Geneva Trust Company. It's formerly known as Rawlinson and Hunter Geneva. And as the panel has heard, when the former trustees were removed as trustees in July 2010, they exercised their right to retain all the TDT assets, affect their right to indemnity in respect of the liabilities, not only to the BVI companies, but also their prospective liabilities for the costs proceeding. Now, the result of that is important because when the new trustees became trustees in July 2010, no assets were transferred to them. Similarly, in September 2017, when Mr. Cengiz removed Rawlinson and Hunter and appointed the current trustees as trustees, the current trustees received no transfer of TDT assets to them. In the Guernsey 1 proceedings, the 5th defendant, the new trustees, were joined, and they counterclaimed that the former trustees had breached their duties to the beneficiaries of the TDT, and that the former trustees were not entitled to exercise their right of indemnity out of the assets. Ultimately, in the Guernsey 1 proceedings, after multiple hearings before Lieutenant Bailiff Chadwick, multiple appeals to the Court of Appeal in Guernsey, and finally 10 separate appeals to the board, Investec and Bayer have succeeded substantially on all the issues. And one sees that from the Investec 1 decision handed down in April 2018. The former trustees also succeeded in parallel proceedings known as Guernsey 3, which were dealt with in Investec 1 too. In Guernsey 3, the successor trustees again sued the former trustees for breach of trust, but the board said in Investec 1 that the Guernsey Court of Appeal had been right to dismiss those claims as an abuse of the process, or because they had no realistic prospect of success. And the former trustees' success in those proceedings was reflected in the board's order for costs dated 18th December 2018, the end of Investec 1, and the former trustees were awarded substantially all their costs of the affected years. But neither the current trustees, nor the previous trustees, nor the BVI companies have satisfied any part of these costs orders in favour of Investec and Bayer, despite the fact that they won. And that's why former trustees had to discharge their legal costs out of their own resources, not the TDT assets. And that's why they're seeking and claim reimbursement out of the assets. Now, in both Guernsey 1 and Guernsey 3, the purpose of the later trustees' claims, both Geneva Trust Company and those claims were continued by the current trustees, Fort and Belt. The purpose was to prevent Investec and Bayer relying on their rights of indemnity. That was the object of the litigation, so far as they were concerned. And yet, Investec and Bayer have succeeded all the claims brought against them by the later trustees. And yet, the current trustees say that the current trustees' costs and Geneva Trust Company's costs of their failed claims against Investec and Bayer should rank pari passu for payment out of the TDT assets with Investec and Bayer's legal costs. That's in spite of the fact that Investec and Bayer's costs were caused largely by the later trustees' adverse claims against the former trustees, and their claims that the former trustees were not entitled to rely on their right of indemnity. And in our respectful submission, the board has to keep in mind the obvious injustice about the later trustees' claims to rank pari passu, and they've sought for 11 years to prevent the trustees relying on their right of indemnity. And that injustice really calls into question the whole legal basis of the current trustees' present case. Can I now turn to the legal question about what is the nature of the right of indemnity and the proprietary interest generated by the right? And this is obviously the fundamental issue which divides the Jersey appellants from the Jersey respondents and the Guernsey respondents. And the fundamental issue is, does a former trustee's right of indemnity out of the trust's assets have priority over a later trustee's? And at the heart of the difference is the question, what proprietary consequences flow from the trustee's right of indemnity? And the former trustees submit that the right of indemnity confers rights of a proprietary character on the former trustees. And this is because the authorities show that the rights affect the trust assets in the hands of present and future trustees. Our main propositions are set out in section C of our written case, and I obviously will try not to repeat them here, but I will do my best to distill them. As the panel will have seen, the former trustees rely on the analysis of the proprietary consequences of the trustees' right of indemnity, which is found in the leading modern authorities in Australia, and which culminate in the recent High Court of Australia's decision in re Amarind, Carter Harvey against Commonwealth. The panel's already been taken to some of the key passages in that judgment, paragraphs 80 to 85, which are also summarised in our written case. I will refer to some further paragraphs later, but I will show the panel that those paragraphs do represent the majority view, the view of Justices Bell, Gageler and Nettle. And one sees at paragraph 106 of the judgment of Her Honour Justice Gordon that she agreed with the written reasons of Justices Bell, Gageler and Nettle. So it represents the majority view. And it represents the majority view on the relationship between the right of indemnity and what the majority regarded as the linked but separate interest of the trustees in the trust assets. The essence of the decision is that the trustee's right of indemnity out of the trust property generates a preferred beneficial interest of a proprietary nature in the trust assets in favour of the trustee. This interest gives the trustee priority of the interest of the beneficiary. Now, it is instructive to look at the way the Australian case law has developed steadily, because it's evident from the development of that law, which I'm not going to be able to take the panel through, but the Australian current analysis is based on the two fundamental principles. One finds stated by Lord Eldon in Worrell and Harford, and by Lord Romilly in the Exall Coal Company case, both of which have already been cited. So I'm not going to take you to the bundles, but just to remind the panel, it's at my references will all be to Guernsey bundle. I'm afraid that's the bundle I've been working from, but at Guernsey bundle 2347 to 9, I'm not asking you to go to it, I'll just read it out. Lord Eldon said in Worrell and Harford, it's in the nature of the office of a trustee, whether expressed in the trust instrument or not, that the trust property shall reimburse him all the charges and expenses incurred in the execution of the trust. That is implied in every such deed. So it is the trust property, not a person, that has to reimburse the trustee his charges and expenses. And secondly, in the Exall Coal Company case, Lord Romilly described the trustee's right of indemnity. It's at GB 2209, and key passages at 2211. Lord Romilly described the trustee's right of indemnity as a right incidental to the character of trustee and inseparable from it, that he should be saved harmless from obligations which are attached inseparably to his office. He said it was the first charge on the trust property. So one sees those features which the Australian courts have built on, that the right of indemnity is an inseparable incident of the office of trustee and the concept of the trust. The right is a right to be saved harmless, so the trustee should not be left out of pocket by liabilities properly incurred as trustee. And it's a right that has proprietary consequences because the trustee's liabilities fall to be discharged out of the trust property. It's not merely a personal claim. And anticipating the argument later, we say it's important when considering the submission made by the appellants that the board should adopt a pari passu principle, which is derived from the statutory schemes that apply to unsecured personal creditors of an insolvent person. Because the equitable rules are about reimbursement and exoneration out of property. The statutory schemes are about the rights of unsecured personal creditors of an insolvent person. And I go back to those fundamental, my lady.
Do you accept then that if there's an insolvent estate, using that term in the sense we've been using it, and there's no difficulty with successive trustees, you just have one trustee with a trust which does not have enough asset, and that trustee has a claim for its own remuneration, it also has paid out to creditors, and there are other creditors to whom it's liable but who it has not yet paid. Do those rank pari passu, or do you say that there's some scheme that there of priorities in that situation?
As regards the creditors have already been paid, they've been paid. And there's no, in Jersey, there's no rule to set aside preferences in this context.
No, but part of the trustee's claim is for that money.
So your latest question is, do the trustees' own claims for reimbursement of expenses it's already paid take priority over the claims of the trustees' creditors who've not yet been paid?
Yes.
Well, that's the issue which the Guernsey Court of Appeal decided in favour of former trustees, and we say that's correct. And the reasons we say it's correct are set out in section F of our written case. But they do depend on separate principles and separate concepts to the ones we're considering at the moment. My Lord Stevens.
I think Lady Rose's question was, what's the priority as between creditors who haven't been paid?
The liability between trust creditors who haven't been paid, where the trustee is administering the fund.
The creditors of a previous trustee, and those creditors have not been paid, and they then bring a subrogated claim through their previous trustee against the trust fund. What's their priorities?
In the hands of the new trustees.
In the hands of the new trustee.
Yes. Well, the way it was dealt with by the Lieutenant Bailiff Marshal at the first instance was that she said it hadn't been, I think, fully argued, but that prime facie, she said it was pari passu, but she gave liberty to anyone to come in and make a different claim.
But if there's no complication, if there's just one trustee, there's only ever been one trustee of the trust fund, and that trustee is owed money, A, for its own fees, B, because it's paid out to creditors, and C, there are other creditors who have not been paid out. So there are those three classes of claims against the trust assets. Are you saying that there's no case that, other than these cases or other than the Australian cases, that deal with that just simple situation where there is a trust fund with those three different kinds of claims against it and an insufficiency of assets? There's no case that decides what priority those three different claims have. Is that where we are?
My lady, the first point is that the Amarant case decides that in some circumstances, the statutory scheme can apply where one has a trustee.
Right. So what does
the statutory scheme might well have the result that it's pari passu, but that's not our position in Jersey or Guernsey, as a result of the fact that the trustees are not personally liable to creditors where they've disclosed that they're trustees, so they're unlikely to go insolvent. So it's in the present case, it's a very special problem of Jersey and Guernsey law because of the impact of Article 32. It is explained in section F of our case, but with respect, it is a slightly different issue for the question of priorities between successive trustees, which I'm trying to deal with.
All I'm trying to work out is, in the general scheme of things, where there is a trustee who is not itself insolvent, but the trust fund is insolvent, how does that trustee pay out the funds to those various creditors? Is there a system which it must adhere to in meeting those claims?
There isn't a scheme fixed by statute, and the present appeals are about what the position should be. That's, my lady, that's I think the problem in Jersey and Guernsey. I'm sorry if I was slow to understand the import of your question, but it's a special problem with Jersey and Guernsey.
There could be a similar problem between successive agents appointed to manage property, e.g. successive consignees of goods. But the point is, it's just never arisen. Nobody's been able to find any case law.
That's my understanding, my lady, yes.
But it isn't unique to trusteeship. This is a problem that affects agents.
Why, Mr. Torb, is it a special problem for Jersey and Guernsey? I mean, what's the difference between the position there and the position on my lady's question, had it been a purely English trust?
If it's been an English trust and the former trustees have incurred liabilities for 180 or with interest something like £230 million and failed to pay, they would be made insolvent. And then the question would have arisen, which arises in the Australian authorities: what's the interaction between the Insolvency Act 1986 and the trustees' rights in relation to the trust property? But that doesn't apply in Jersey or Guernsey, because Investec and Buyer are not personally liable and cannot be made bankrupt or insolvent as a result of those liabilities.
So it's the fact that they, yeah.
It flows from Article 32 and the interpretation put on Article 32 by the board in the previous.
Because, yeah.
What I was submitting was that the proprietary consequences of the right of indemnity, which the English and Australian authorities have identified, apply equally to trusts governed by the law of Jersey for the following reasons. The board will recall from paragraphs 56 to 58 of the Investec 1 case, as well as a case called Spread Trustee Company Limited in Hutchinson, which was from Guernsey, which can be found, I'll give the reference, I'm not going to go to it, Guernsey Bundle 4631, that in Jersey and Guernsey, their legal systems imported the English concept of the trust, and in the Spread Trustees case, it was found that it was not the Scottish concept of the trust which had been imported. It was the English concept of the trust which was imported into Jersey and Guernsey, and their respective statutory trust laws came later. And on that basis, the point was made that the English trust law principles will generally apply to Jersey or Guernsey trusts, save where there is something in the customary law or statute that is incompatible. And on that basis, Investec and Buyer submit that the trust laws of Jersey and Guernsey necessarily imported with the English concept of the trust. The trustee's right to be indemnified out of trust property, and the proprietary consequences of that right of indemnity, which are built on the principles in Worrell and Harford and Exor Coal Company. And that's because those rights and proprietary consequences are inseparable incidents of the English Trust and the Office of Trustee.
Can Article 32, I'm sorry to interrupt, but at some point I'd like you to answer this. Why can Article 32 work unless there is some means of the creditors of the original trustee having access to the assets for the time being at the time of their claim?
Yeah, my lady, if I may respectfully say, the answer is no, Article 32 can't work unless that's the case. And I was going to come, my next submissions are going to be based on the Trust Jersey law. And could we please go to the Guernsey bundle at 1948, where one has the Trust's Jersey law. And
Yes, Mr. Torb, I don't know if you can hear me, but I just would like to thank those instructing you and other counsel for just having delivered a full set of hard copy bundles. I'm extremely grateful. Thank you.
Well, I think the credit goes to Ms. Warnock-Smith. I'd like to take credit myself. Ms. Warnock-Smith.
Well, my very sincere thanks to those who have done that for me. Thank you.
So at 1948, one finds Article 1 in definition, and at 1949, one sees that the term trust, bottom of the page, includes the trust property. And over the page, trust property means the property for the time being held in trust. If one then goes to page 19453, one gets to Article 26, subparagraph 2. A trustee may reimburse himself or herself out of the trust. And one has to insert there the word property because of the definitions I've already shown. So it reads, a trustee may reimburse himself or herself out of the trust property for, or pay out of the trust property, all expenses and liabilities reasonably incurred in connection with the trust. So it's a right to be paid out of the trust property. It's not a personal claim. And we submit that the language echoes so closely the language in Worrell and Harford that it must be inferred that the Jersey legislature intended the same rule with the same proprietary consequences as exist in English and Commonwealth trust law in respect of the right of indemnity. And it's on that footing that we submit trust law of Jersey and Guernsey follows English and Commonwealth trust law in the authorities which we're now going to consider in Carter Holt and so forth. If time had permitted, I would have tried to show a panel the cases leading up, the most important cases leading up to Carter Holt. The two most important are Octavo, which is in the Guernsey bundle at 3535. And the most important section is at 3542. It's quoted in almost every subsequent Australian authority on the subject, and it's, when one looks at it, one sees it's based on the same fundamental English principles. But it draws attention to the fact that the trustee's right of indemnity means that for the purpose of enforcing it, the trustee had a charge or right of lien over the whole trust assets. And this amounted to a prior beneficial interest in them. In 1998, in a case called Buckle, which I do want to go to, which is at Guernsey Bundle 2024, the law developed further, and the issue was that the trustees had appointed a defeasible vested interest in favour of two beneficiaries of what was previously a discretionary trust. And the trustees had substantial liabilities, almost equal to the value of the trust. And the question arose whether the substantial liabilities of the trustee represented an encumbrance on the property which was the subject of the appointment in favour of the beneficiaries. Was it an encumbrance on the beneficiaries? And the High Court of Australia said no. And this was because the beneficiaries' interests took effect subject to the preferred beneficial interest of the trustees generated by the right indemnity. And one goes, please, to page 2043, paragraph 47, and sees that the consideration of the issue as to whether or not the liabilities of the trustees would or not give rise to an encumbrance upon the beneficial interest starts with Worrell and Harther. And then, after setting out the principle there, going over the page 2044, midway through paragraph 47, it said from the top of the page, in aid of the trustee's right to reimbursement or exoneration for liabilities properly incurred in the administration of the trust, the trustee cannot be compelled to surrender the trust property to the beneficiaries until the claim has been satisfied. In that sense, the entitlement to reimbursement or exoneration confers a priority in the further administration of the trust. Accordingly, in an administration action, if it appears probable the trust fund will be insufficient for the full recoupment of the trustee is entitled to the insertion in the order for the administration of a direction that there be payment in the appropriate order of priority. Until the right to reimbursement or exoneration has been satisfied, it's impossible to say what the trust fund is. The entitlement of the beneficiaries in respect of the assets held by the trustees which constitute the property to which the beneficiary is entitled in equity is to be distinguished from the assets themselves. Then skipping the sentence. To the extent that the assets held by the trustee are subject to their application to reimburse or exonerate the trustee, they are not trust assets or trust property in the sense that they're held solely upon the trusts imposing fiduciary duties which bind the trustee in favour of the beneficiaries. And at the bottom of the page, paragraph 57 sentence, the term trust assets may be used to identify those held by the trustee upon the terms of the trust. But in respect to such assets, there exist the respective proprietary rights in order of priority of the trustee and the beneficiary. Again, if I can skip, a court of equity may authorize the sale of assets held by the trustee so as to satisfy the right to reimbursement or exoneration. In that sense, there is an equitable charge over the trust assets, which may be enforced as the same way as any other equitable charge. However, the enforcement of the charge is an exercise of the prior rights conferred upon the trustee as a necessary incident of the office of trustee. It is not a security interest or right which has been created, whether consensually or by operation of law, over the interests of the beneficiaries. And the High Court of Australia endorsed and said they agreed with the treatment of the matter by His Honour Justice Appeal Scheller in the Court of Appeal, who, see it paragraph 51, concluded that the trustee has a preferred beneficial interest in the trust fund. And we say, for reasons which I'll develop further, that it's equally true of the situation where a trustee is removed and retains assets to protect its right of indemnity. Those who come after the former trustees take their interests in trust property, subject to the former trustees' rights in the assets. Substance, new trustees and beneficiaries have an equitable right to what's left, subject to the trustees' indemnity.
Does the original trustee have to retain possession for that purpose?
My lady, we would say not, but we'd say the position is a fortiori where it's retained. Assets.
Yeah. Thank you.
Mr. Todd, there's nothing in Buckle, is there, that's expressly looking at the position between successive trustees?
That's correct, my lord, and nor indeed is there in Carter Holt.
Right.
And we have to accept that there is no binding authority in the High Court of Australia which deals with that. The closest we get to it, which I will come to, is the Augusta case, which is in the Court of Appeal of New South Wales. Can I then go, please, to Carter Holt, which is at in the Guernsey bundle at 2133. If one skips ahead, one sees at 2154, 2155 are the passages, 2156 are the passages to which the court's already been referred. If I could draw attention to one point, which I'm not sure was read, which is on 2156. Paragraph 85 is the majority view in several of the authorities, and thus in the proceedings below, the property of a trustee available for the payment of creditors in the event of insolvency is described as being the right of indemnity. That is so in the sense that the trustee's right of indemnity confers a beneficial interest in the trust assets. As this case demonstrates, however, it is necessary to keep in mind that the property constituted of the right of indemnity as such, and the property constituted of the trust assets themselves, are separate and distinct, albeit that the former confers a proprietary interest in the latter. And that is part of the ratio of the case, because it's one reads the judgments at length, one sees that's where it's said that at first instance was just His Honour Justice Robson went wrong. If one goes over to 2161, one finds the judgment of Her Honour Judge Gordon, and at 2161 paragraph 106, she says that she rejects the arguments of the appellant that the statutory scheme didn't apply. I agree with what Bell, Gagel and Metal have written. I write separately to explain my reasons why at the level of principle and practice the appeal should be dismissed with costs. So this is, so to speak, supplemental to the majority of opinion. Going to 2165, she cites judgment Chief Justice Alsop in Jones and Matrix, and at 134 you will see that again he stressed this distinction between the right of exoneration and the interest it generates. In one sense, what exists can be seen in an equitable, can be seen to be an equitable proprietary interest or charge or lien in or over the trust assets. That any enforcement by a court of equity is not a security interest or a right created over the interests of the beneficiaries, but rather the enforcement by a court of equity of a prior proprietary interest in the trust fund to support the right of indemnity. And Her Honour continues, the approach of J to the right of exoneration, and particularly his explanation, the right of exoneration generates a proprietary interest in the trust fund, was consistent with a number of decisions of this court. Could I then ask you, there's an interesting analysis, which I commend, but I haven't got time to go through, but can I take court to paragraph 142, which is at 2167, which contains a critical passage when it comes to ascertaining at what point the proprietary right arises of the trustee, that proprietary right being based on the right of indemnity. At 4 sentences down, Her Honour says, the trustee's right of exoneration confers a proprietary interest in the trust fund, which takes priority over competing interests of beneficiaries. The right of exoneration and the trustee's proprietary interest in the trust fund are inextricably linked. The trustee's interest in the fund rises and falls as debts are incurred on behalf of the trust and satisfied out of the fund. And of course, the right of exoneration is the basis for the existence of the trustee's fluctuating proprietary interest in the trust. And you'll see that there's a footnote 177 to a case called Re-Independent Contractor Service Australia, 2016. And that is one can find, I'm not asking court to go there, but one can find at 4091 that decision, the decision of Justice Brereton in New South Wales, and at 4010 one finds the paragraph 24 which is footnoted by Her Honour. And in that paragraph, what Justice Brereton proposed was that there's an analogy with a floating charge. He didn't say that trustee's right of indemnity is a floating charge. There's an analogy. And so the amount secured rises and falls. It takes effect, obviously, from the grant of the floating charge, but the amount secured rises and falls over time. And the reason why I mention is because in the Z Trust case, Justice of Appeal Logan Martin appears to have relied on the same passage at paragraph 190 of his judgment in the Z Trust case. And so it was on the basis of a principle which at the time was stated, found in a first instance authority in New South Wales, but now has been endorsed at least by Justice Gordon in the Amarant case.
Is it really helpful to call it a floating charge, in the nature of a floating charge?
No, my lady, no.
It's a fluctuating beneficial interest.
Yes, but I think I respectfully say it's not helpful to try to press an analogy. But the reason for the analogy was to point to the fact that it's the date the charge is granted, which is when it ranks from, and then the value fluctuates as debts go up and down.
I mean, there are other analogies in trust law where that occurs, where you have fluctuating interests. We don't call them floating charges.
No. So,
Mr. Paul, the analogy goes this far, doesn't it? But pending the enforcement by a former trustee of his right, the successor trustee can administer the trust by, for example, distributing, selling, or charging assets within the trust fund.
Yes, my lord. Subject to a point I'm going to make in a moment. which one finds in the authorities about there being a duty on the new trustee, once he holds the trust assets, not to damage, diminish, or jeopardize the former trustee's security right.
Yes, I mean, take a perfectly solvent trust with, everybody assumes, relatively modest former trustee ongoing claims in relation to future or contingent liabilities. Subject to not jeopardizing that right, the successor trustee can administer the trust in the usual way.
Exactly.
Yeah. And anybody who takes trust property by virtue of such acts of administration, whether he's a volunteer, i.e. a beneficiary, or a purchaser, doesn't have to worry about the former trustee's proprietary interest.
Subject, of course, to there not having been a breach of duty by the new trustee. My lord, yes. Yeah.
Well, yes, but even then, the recipient would have to have some kind of notice of that breach if he was to be affected.
There would be some need to rely on those sorts of principles. Yes, ma'am.
Yeah.
But that's quite different from operating under a floating charge, where there is a license to carry on business and deal with assets in the ordinary course of business. But that it's a special duty which you have just referred to, which makes it quite different from a floating charge.
Well, my lady, that's why I said in response to your ladyship's question, it's not possible to press the analogy too far.
Thank you, I've understood. Thank you.
Mr. Torb, can I just ask you about the use of the word proprietary interest? While the assets are available to be dealt with by the successor trustee in the ordinary way, without damaging the former trustee's rights of indemnity, is it right to talk about a proprietary interest in those assets?
Well, it comes back to the question that was canvassed by the panel yesterday. The question is, what are the rights that the former trustee has in respect of the administration of the trust fund going forward? What is the former trustee able to obtain by way of relief if he goes to the court? And we'd respectfully submit that there are cases where it is clear that the former trustee's rights will be proprietary in character because they bind the assets in the hands of the new trustees.
I suppose it was this rather imperfect analogy with floating charges which prompted this thought, because while the floating charge remains uncrystallized, I don't think it would be right to say the floating charge holder has a proprietary interest in the company's assets which are subject to the floating charge.
And I entirely understand what the Lordship's saying. This is one of the reasons why in the Court of Appeal it was suggested that the floating charge, that the Jersey court had been wrong to refer to the analogy and indeed had treated the former trustee's rights as a floating charge. But it was pointed out that that's not what in fact had been suggested. No one has suggested that the former trustee's rights are a floating charge. It's just that there are certain analogies, and so far as the former trustees in this case are concerned, we rely on the analogy because to the extent found in paragraph 142 of the hammering judge. It's the question of date of rank. I see I'm happy to go on, but we've got to 2 minutes past 1.
Can I just leave you with this question? Could it possibly be said that the administration of the trust property by the successor trustee, otherwise than in breach of his duty to respect the former trustee's right, would overreach the former trustee's proprietary interest, co-own the assets which are then distributed out of the trust?
Could I think about that that poser before over the adjournment? Thank you. My Lord Reed, I'm afraid you're on mute.
Oh. I was just remarking that was a very judicious response. We'll adjourn now and resume at 2 o'clock.